Everyone to today's webinar. Thank you for attending. My name is Sophie Parker. Today's webinar is on the topic clarifying remediation responsibility for contaminated land and will be presented by Lavan Legal Partner Craig Wallace and Solicitor Tom Mouritz. Before we meet the speakers, I'd like to give you a brief overview of today's webinar. If you have any difficulties viewing the presentation, please call Anna Morgan on 0419 946 570. We invite you to ask questions at any time during the presentation. Please use the chat box on your screen to enter your questions, and we will respond to as many as possible. If you're a legal practitioner and would like to receive CPD points for this webinar, it is important that you remain in attendance for the duration of the webinar. I'd now like to introduce our speakers. Craig Wallace is a partner in Lavan Legal's Planning, Environment and Land Compensation team within the Property Services Group. Craig has over 13 years' experience in the areas of planning, environment and land compensation and has practiced in both the UK and Australia. He's provided advice to a wide range of clients on all aspects of approvals required in a development context, including development and subdivision approvals, environmental approvals for state and federal government, and the conduct of statutory appeals in the State Administrative Tribunal and the Supreme Court. Craig has also advised on all aspects of the Contaminated Sites Act, conducted land compensation claims for compulsory acquisition, has had the conduct of environmental due diligence for significant corporate and property transactions, and has defended prosecutions in the Magistrates Court brought under the Environmental Protection Act and Planning and Development Act. Our other presenter today is Tom Mouritz, a solicitor who works alongside Craig in the Planning and Environment and Land Compensation team. Tom worked as an associate to his Honour Judge David Parry, Deputy President of the State Administrative Tribunal. Tom was exposed to a wide range of matters falling within the Tribunal's jurisdiction, particularly in the development and resources stream. Prior to commencing his career in law, Tom worked in town planning roles in local government. Tom's responsibility ranged from strategic planning and sustainability policy review at the Town of Vincent and the development assessment in the fast-growing Blacktown City Council in Western Sydney. Since being employed at Lavan Legal, Tom has had the conduct of matters including appeals to the State Administrative Tribunal on a range of planning-related issues and has advised clients on all aspects of the Environmental Protection Act and Contaminated Sites Act. Thank you for joining us today, Craig and Tom. I'll now hand over to you.
Thank you, Sophie. My name is Craig Wallace. I'm the foreign sounding one, and this is Tom Mouritz.
Hi everyone, this is Tom.
The topic this afternoon is clarifying remediation responsibility for contaminated land. What we want to do this afternoon is bring you up to speed in relation to the latest developments in the area, and also to outline some of our experiences and thoughts in relation to those developments. We hope to provide you with some points to take away that may be of some assistance in relation to how you practice or in relation to properties that you're responsible for. So I understand that the audience for this particular seminar is fairly varied. And what I propose to do is to provide you with a quick overview of the Contaminated Sites Act. And I want to do that by focusing on the definition and outlining how you assess responsibility for remediation. We'll also examine some recent decisions coming out of the Supreme Court in relation to decisions of the Contaminated Sites Committee, and then provide you with some takeaways in relation to how those decisions impact on the responsibility for remediation. So, by way of starting, I'll ask Tom to outline for you, very briefly, an outline of the Act.
Thanks, Craig. So yeah, just briefly, some of the key functions of the Act that we're going to talk about today include identifying contaminated land by reference to definition as it is under the Act, introducing the obligation to report, establishing a system for the classification of sites, and setting out what is the mechanism for determining and transferring responsibility for remediation. Now, defining contaminated land is very important. At the heart of the operation of the Act is the definition of contaminated land. Section 4 of the Act states that in relation to land, water or a site, It means having a substance present in or on that land, water or site at above background concentrations that presents or has the potential to present a risk of harm to human health, the environment, or any environmental value. It might seem simple, however, in our experience, it is that the intent of the provision is often lost in translation. In fact, the technical definition is sometimes superseded by common perceptions of what the media, the public, and the proponent might understand of what contaminated actually means. It's also worth pointing out as well that there's circumstances where the technical definition is used too loosely by environmental professionals, including lawyers. For that reason, we think it's important to revisit the definition to ensure that it's well understood by all of us that deal with contaminated sites that are being assessed and or managed.
And I'll demonstrate that loss of interpretation through these two pictures. As you'll see, on the left-hand side is a petrol station, a fairly dirty one by first impressions, and on the right-hand side you'll see a market garden, nice green vegetables growing in the background. First impressions would suggest that the service station, or the petrol station on the left, is contaminated, and you would be right to draw those conclusions. However, the reality or the risk associated with contamination would only be known in the circumstances that you do a little bit of digging. For instance, in relation to the service station site, the definition of contaminated would only be met in the circumstances that a leak or some form of risk to the environment or environmental value could be met. On the other hand, in relation to market gardens, despite the fact that you have vegetables grown or organically, so to speak, there is every likelihood that there are fertilizers used and pesticides used in relation to that piece of land, and it's invariable that the land is contaminated. So there is some magic to it, and for that reason, an understanding of the definition is fundamental. So what I want to do is highlight the key elements of that definition for the purposes of this talk. And those key elements are as follows. First of all, the contaminant has to be present in the environment. Secondly, it has to be above background concentration. Those two aspects are fairly straightforward and require a scientific assessment. It's not, it shouldn't be difficult to understand that particular aspect. The third aspect, however, is a bit more problematic because it suggests that that concentration has to be high enough to pose a risk or adverse impact to human health, the environment, or an environmental value. And it's in relation to that aspect, the risk assessment, that we experience more difficulty on a day-to-day basis. And arguably we shouldn't, because the policy position in relation to risk has been long-standing, and it's set out quite clearly in the BEC Management Series guidelines. The policy position is such that the assessment of risk takes the form of identifying a contamination source, the pathway of exposure, and the presence of a receptor. And graphically, if I was to represent it, the assessment works something like this. This is a graphical representation of a conceptual site model, something that you'd see arising from a consultant's report or somewhere around a preliminary site investigation level. What you need to do in order to assess the risk is, first of all, understand the nature and distribution of the source. And as you can see in that particular slide, it's a factory and a couple of barrels that are leaking into the environment. Secondly, you need to understand the environmental sensitivity of the receptor. And in that particular slide, it's one of two things: the ecosystem with the ducks floating in the pond, or the residential home that has a well attached to it. And then lastly, you have to identify the plausible linkages between the two. And the reality is, or the fundamental position is, if there are no plausible linkages, the definition of contaminated isn't met, irrespective of the presence of a contaminant. So in that particular scenario, dust from the factory linking to the residential home would potentially meet that definition. Likewise, runoff from the leaking barrels to the residential home would meet that definition, and leaching of the of contaminant into groundwater affecting the ecosystem as well as the water well for the residential home would also meet that definition. Now, getting it right is extremely important because there are two important consequences that flow from it, and I'll get Tom to explain those.
Thanks, Greg. Right, the first issue relates to the obligation to report under Section 11 of the Act. By way of reminder, only 3 classes of people are obliged to report under the Act. They are the owner of the site or the occupier, a person who knows or thinks that they may have caused or contributed to the contamination, and an environmental auditor when engaged in situations where a report is required. For example, when the site has become a source site for the purpose of the Act. Any other person may report, however, there's not the same statutory obligation. The site must be reported within 21 days of discovering known contamination, or if it's suspected, as soon as it's reasonably practical to do so. If not, there's a risk of prosecution and a penalty for failure to comply. And obviously there's a potentially hefty sum that could be imposed if this obligation is not met. Now, going to the way that the sites are classified, Regulation 6 of the Contaminated Sites Regulations require the reporting of a site which is known or suspected to be contaminated through the submission of a Form 1 to the Department of Environment and Regulation. Following receipt of the Form 1, the DER will classify the site according to specific criteria. Classifications that could be applied and which are set out at Section 15 of the Act include report not substantiated, possibly contaminated, investigation required, not contaminated, unrestricted use, contaminated with restricted use, contaminated, remediation required, remediated for restricted use, or decontaminated.
Now, I'll interject there, Tom. The classifications that cause us most difficulty in my experience are possibly contaminated, investigation required. And the reason for that is because it implies some contamination or an issue in relation to the land. But it doesn't quite explain what that risk is. And as a consequence, there's an underlying uncertainty in relation to what you can do on that land, and that has implications for value. Equally, the classification of contaminated remediation required also has some important implications in my experience, because what it does do is it immediately constrains development, or what you can do with pieces of land, and it also implies cost in relation to remediation, and that for most operators and landowners out there is a significant concern.
Right, moving on, continuing with classification and the consequences. Classification of sites in WA over the last 6 years since the Act has been in operation reveals that significant consequences can arise for those with an interest in a piece of land, depending on the classification that's given. These could include a requirement for a notification to be placed on the title, or perhaps as well as be added to the Contaminated Sites database. It could be a perceived negative impact on value by prospective purchasers and mortgagees. There could be the trigger for disclosure obligations to potential purchasers, which is subject to a penalty of up to $125,000 in the event of a breach. It could be the need for further investigation in the future in circumstances that reclassification of the site is pursued. And lastly, there's obvious implications for landowners and occupiers to remediation responsibility under the Act.
And moving on to remediation responsibility, this is the question that's most asked of us as legal practitioners. How is responsibility for contamination determined? And it's not that easy to explain. So by way of brief background as to the mechanism, the Contaminated Sites Committee has been set up in order to undertake that function. Now, the assessment of remediation responsibility is fairly limited, because the application can only be made by an interested person. Now, that term is defined in the Act to include entities or persons with linkages to the property concerned. And also, the application can only be made in circumstances where the land is classified as contaminated remediation required. Now, you might find that to be perfectly sage, but there are circumstances that you want certainty in relation to areas of land that don't have that definition. Now, the Contaminated Sites Committee is required to make its assessment in accordance with equity, good conscience and substantial merits. What they will do is take into account the hierarchy of responsibility, which I'll expand on a bit later, the nature and extent of the contamination. We're looking fundamentally at the definition set out in Section 4 of the Act, land uses, and there's a useful guidance note on the DER website in that regard in relation to potentially contaminated land uses. Any submission made to the Contaminated Sites Committee. In my experience, this is the area that most guidance is obtained from the committee's perspective, and also in relation to relevant reports made to the DER. And this is important because what happens here is that in circumstances that the application is made for an assessment, the first thing the Contaminated Sites Committee is write to another branch of the DER and request copies of all reports relating to incidents arising throughout the history of that particular site. Now, perhaps the most difficult aspect of explaining responsibility, or how responsibility is assessed, is the hierarchy of responsibility. Now, our legislation sets out a hierarchy and indicates who should be responsible when, and essentially a sliding scale. If you can't find the first person in the list, you go to the second person. If you can't find the second person, you go to the third person. And this is my interpretation of the hierarchy. As it's set out in the Act, I find it fundamentally difficult to read. I find it difficult to understand. So this is my interpretation. I'm very happy to take your comments in relation to what you think of it, and hopefully it simplifies it to a degree that it's actually usable. So the basic premise of the hierarchy is that the polluter pays. That's the fundamental position that the Act is based on. And as you see, the polluter is third down on the list, and I'll explain how I get there. So you start off with the polluter, and one of the way the Act works is that it separates timeframes for a particular contamination event. Those timeframes are either pre-commencement of the Act or post-commencement of the Act in 2006. Relevant to polluters, if you are a polluter prior to the commencement of the Act, you are only a polluter for the purposes of the hierarchy in circumstances that you did so without lawful authority. What that means is that if you had a license to pollute pursuant to the Environmental Protection Act, you aren't on this list. However, after the commencement of the Act, it doesn't matter whether or not you have a license, because you will be in the list with or without that lawful authority. If we move down from polluters, what you'll notice that after polluter, if you can't find a polluter, you next go to the owner. And the owner, interestingly, in the Contaminated Sites Act, includes a whole range of entities, including mortgagees in possession, which is relevant from a banking perspective, and something that causes a degree of risk, particularly in relation to potentially contaminated land uses and the ability to obtain funding. So certainty is a valuable commodity in relation to funding. Importantly, the definition of owner would also include insolvency situations. So, for instance, in an insolvency situation, the responsibility can extend to the director of the insolvent entity, and that's set out in Section 28 of the Act. And in the instances that an owner is unable to be found, well, then responsibility falls to the state pursuant to Section 29. You'll notice that there's two exceptions set out in that particular hierarchy or my structure, and there are items that I want to draw to your attention. The first is an owner or occupier changing the use of the site. Now, Section 26 of the Act is in essence a mechanism for the transfer of responsibility by state. It's a very broad section of the Act, but what it essentially says is that if a landowner or an occupier proposes to change the use of the land such that it is required to be remediated, for instance, industrial land moving to residential land, then they become first in line for responsibility to remediate pursuant to the Act. It's important to understand that it includes both owners and occupiers. Occupiers is very broadly defined in the Act and can include entities that merely have responsibility for some aspect of control of the land. So, for instance, tenants obtaining development approvals for the change of use would be responsible pursuant to the hierarchy. The next in line is probably a little bit more contentious, and I'd happily take comments or some discussions over a cup of coffee about it. It's an owner who obtained the land pre-commencement of the act with knowledge of the contamination. And from my perspective, it's put above the polluter. And I think the reason it's there is essentially it's a form of punishment, really, and probably an acknowledgement that you should have known better if you knew about the contamination. Now, I've just had a question come through. Clearly, owner and occupier are defined in the Act, and they're fairly readily ascertainable. However, definition for polluter is a little bit more circumspect, and it's not set out in the Act. Tom, are you able to expand on what a polluter is?
Thanks, Craig. It's not a term that's actually defined in the Act, but in relation to the Coffey No. 2 decision, which we're going to discuss later in a bit more depth, I do recall that Justice Hall made some comments that could assist in this regard. He was considering some arguments raised by the applicant in relation to potential defence provisions of the Environmental Protection Act, and Justice Hall drew on the term pollution as is defined under the EP Act there. He also made some comments or took from the Palos Verdes and Carbon case from 1991, where it was stated that the definition of pollution should be informed by the ordinary meaning of that word as involving the introduction of harmful contaminants into the environment. So I think we can draw from that discussion in that case that a similar application can be used to determine what a polluter is under the Contaminated Sites legislation.
Well, thanks, Tom. I think really it's a matter of common sense too, and we'll probably expand upon it in relation to some of the case references that we'll refer to, and in particular how you get to lawful authority. In relation to apportionment of responsibility, it's important to understand that decisions made by the committee have significant implications for landowners and occupiers alike, not just of contaminated sites, but also affected sites. And this is particularly so in light of recent decisions at the Supreme Court in relation to the BP Australia case, and two decisions relating to the same site, Coffey No. 1 and Coffey No. 2. We'll examine them both. I'll run through the BP Australia case, and Tom will run through the Coffey cases. Now, I note, for starters, that we might have someone in the audience that sits on the Contaminated Sites Committee, so I'll be circumspect with my criticism and defer to the difficult position that the Contaminated Sites Committee have. So, for starters, and I'll have to apologise here, case law is inherently turgid, and for all those non-lawyers out there, I apologise in advance in relation to some of the terminology used, but hopefully at the end of it we'll derive some useful comments from you, and we'll close off with a couple of points for you to take away. So, the BP Australia case, interesting case, and I'll give you a brief background. As you'll see from the picture, there's a yellow box around the site, and you'll see a directional arrow and a red oval implying the plume. Now, this case involved a service station site in Lansdale. The service station had operated consistently since 1977, and as you can imagine, over such a long period of time, the owners and operators had changed. In 2006, contamination was identified and reported to the department. On the 16th of November 2007, the site was classified as potentially contaminated, which investigation required. In 2008, post that investigation, the site was reclassified as contaminated, remediation required. And it was at that time that the owners sought a decision in relation to the apportionment of responsibility. and it's that decision that's the subject of the appeal to the Supreme Court. But before I get there, what I want to do is try and make some sense of the Contaminated Sites Committee decision. Not a critique, but an understanding of the difficult task that they face. It's complex to my own eye, somewhat perplexing, and clearly demonstrates the limited and sometimes fractious information that the Contaminated Sites Committee receive in relation to who's responsible for what. So in essence, I've tried to demonstrate the history or the background in relation to who did what in graphical terms. So what the Contaminated Sites Committee did was they separated the operation of the facility into separate time frames. And relevantly, they found 5 periods that were which they considered relevant to the determination or assessment of contamination responsibility. And those periods, if you look at the bottom of the slide, were 6, 7, and 8 between 1992 and 1997, and periods 11 and 12 between 2001 and 2003. And the rationale for those periods will become relevant later. The apportionment for responsibility was based on time and an assumption of who had responsibility for what during that time. So if we start from the top, Mr. Serenich, he acquired 5% responsibility. He was a former owner of the site for a brief period of time, around about 1997. He, you go right down to the bottom of the triangle, you see El Dasuki obtained 41%. They were also an owner of the site, and they still are. Serenich and El Dasuki both co-owned the site for a very brief period of time, and during that time, something was made in relation to lawful authority, which necessitated a decision in relation to responsibility. The next in the list is White Gum Petroleum. They've been the lessee of the site since 1997. They operate the site, and essentially their responsibility relates to periods 11 and 12, and that's an incident that occurred during that period. BP had historical involvement in the site from 1992 to 1997 as the lessee and the franchisor of the land. You'll see what's missing there is the owner around about that time, and the owners in that regard weren't, from my memory of the case, weren't attributed responsibility because they were either entities that couldn't be found or no longer existed. So BP copped 36% because they had some responsibility for the site, and explain how that was assessed a bit later. And then lastly, Mr. and Mrs. El Dasuki, 41%. They had the unfortunate circumstance of not only being the sub-lessee and the operator of the site during periods 6, 7, and 8, but they also acquired the site in post that period and were owners for the periods 11 and 12 as well. So just by way of some explanation of where that sits in the hierarchy of responsibility, fair and square, from my perspective anyway, all of those entities are polluters, pre-commencement of the Act, without lawful authority, and I'll explain how that's derived now. Now the decision, as I said, was split into 2 separate timeframes, periods 6, 7, and 8, and periods 11 and 12. Periods 11 and 12, if you go to the bottom of the slide, relate to a spill, and really a simple task for the committee. The polluter responsible for that spill was found to be responsible, so that was fairly straightforward. Period 6, 7, and 8, slightly different, because the contamination event there was attributed to a leaky anaconda joint or faulty infrastructure related to the service station site. And interestingly, responsibility for that contamination was split 50-50 between that entity responsible for the maintenance of the equipment and that entity that continued to use the site whilst in disrepair. Now, if I take you back to the BP, who were the franchisor, and El Dasuki, who were the franchisee at the time, example, BP would have sustained 50% responsibility as a consequence of their responsibility under the franchise agreements, under the lease agreements, to maintain the infrastructure, and that's fairly common in service station agreements. Aldasuki copped the balance of the percentage. Well, despite the fact that they weren't responsible for maintaining the equipment, the assumption was made that they acted without lawful authority because they continued to use the equipment whilst in disrepair. Now, how the Contaminated Sites Committee arrived at that conclusion is based on a strict application of Section 49 of the Environmental Protection Act. Now, Section 49 is the section in the Environmental Protection Act that applies an offence for causing pollution. And the suggestion or the assumption made was that in the event that you contribute to contribution, you are liable to an offence pursuant to Section 49, and as a consequence, you have acted unlawfully. Interestingly, there's no conviction there, and there was, in fact, no proceedings brought by the DEC or the ER as it now is in that regard. So primarily based on an assumption. Moving on to the appeal, the appeal was brought by BP, who you'll recall acquired 36% of the site. Importantly, it's acknowledged that appeals in relation to decisions of the Contaminated Sites Committee are limited to a question of law only, just a common position in judicial review methods. Their appeal was based on 9 grounds, which I'll summarise very briefly as under 2 broad headings. 1, the application of Section 49 to determine unlawful authority, and 2, in relation to procedural fairness. And BP took issue with the fact that the Contaminated Sites Committee failed to take into account relevant considerations and also provided a statement of reasons that were inadequate. Chief Justice Wayne Martin gave the judgment in this matter, and I have to say he was absolutely scathing of the solicitors that brought it. Firstly, not only did he confirm or affirm the Contaminated Sites Committee decision and dismiss the appeal, but he also commented that the appeal was, and I quote, prolix, repetitive, confused, and manifestly short of understanding. Quite a criticism of the solicitors bringing the action. The Chief Justice confirmed that rights of appeal are limited to questions of law, and he made no bones about it. He referred, in fact, to the Paradis decision for those in the audience that are lawyers, and a fairly familiar decision in judicial review terms. And in relation to the lawful authority point, he commented that the Contaminated Sites Committee weren't required to apply a criminal standard of proof. They weren't required to prove beyond reasonable doubt that an offence had been committed. It was sufficient for them to exercise their judgment in that regard. And that is essentially a value judgment made by the committee as to whether or not an entity is a polluter for the purposes of the Act. In relation to procedural fairness, the Chief Justice commented that the appeal was fairly problematic because what it did was it posed itself as a challenge on the merits and not as a question of law. And as a consequence, he couldn't consider it, and he essentially dismissed large portions of the grounds of appeal on that basis. In relation to the adequacy of the content of reasons, he suggested that the adequacy of reasons depends on the facts. In this particular circumstance, he was content with the reasons that as they were presented. And interestingly, what he refused to do is apply what he calls a fine appellate tooth comb to the reasons, and that's to take into account the non-judicial nature of the Contaminated Sites Committee. In terms of significance of that judgment, it's a very important one, and it certainly sets the scene as to how difficult the Contaminated Sites Committee task is, and how limited the appeal rights are. Illustrative of the difficulty that Contaminated Sites Committee face. Clearly, there's evidentiary issues. Clearly, in requesting information from parties involved, the responses are factious, one-sided. They're unable to be cross-examined, and they invariably relate to contractual disputes between parties. That's problematic in the sense of assessing responsibility because the Contaminated Sites Committee has to make a decision, and as a consequence has to draw some assumptions in that regard. What this case also does is it validates the committee's approach to determining responsibility based on unlawful authority. And from my perspective, that's a real issue in circumstances that you don't have the science to back it up. The Contaminated Sites Committee have to make a decision. If they don't have the evidence, they have to make a best case judgment on what's been presented to them. That has the consequence that unfair results arise. And in particular, looking at this particular decision, you have BP, a global company, acquiring 36% for, in essence, what was their involvement in a very biased franchise arrangement. And Mr. and Mrs. Awasuki, a retired couple, copying 41%, clearly not having the same financial clout that BP has. So the results are somewhat one-sided as a consequence. And moving on to the next case.
Yeah, I'm just going to go through the Coffey decisions, of which there was two. Just as some background, the Coffey matters related to a site in Osborne Park with a history of use by various tenants as a petrol and fuel service station and associated motor vehicle workshop. The site was classified as contaminated following referral under the Act by the site's owner in 2008. Some controversy subsequently arose as to whether the applicant, Coffey, which is an environmental consultancy, had caused damage to a pipeline in the course of conducting investigations in 2004, which it was thought consequently led to contamination. Following several years of correspondence between the committee and the applicant, Coffey, the committee ultimately provided Coffey with a notice under Section 37 of the Act, which is an invitation to provide responsive submissions to what is a kind of a draft preliminary indication of the decision that the committee might be making as to the responsibility for the remediation of the site. Now, Coffey weren't happy upon receipt of the Section 37 notice and sought judicial relief in the courts. Now, the grounds for review in Coffey number 1 case, and excuse me as I digress into some Latin, and I come from a background at SAT where there's near universal exclusion of Latin phrases, but it's important to note that this was an ex parte application, which means that there was just one party making the application in the court. That is to say, there weren't any contradictors of the applicant's position. It's quite important to recognise this because, as is apparent later on, when we look at the Coffey number 2 decision, the judge's consideration of a matter, even at this early stage, is likely to be much different when there's no one present on the other side to argue an alternative position. Now, the application was for a show cause order, or order nisi, declaring that the Section 37 notice was invalid. Essentially, Coffey's grounds were a failure to comply with statutory requirements as set out in the Act, a failure to provide sufficient reasons as to why they provided the Section 37 notice, and a failure to conduct an oral hearing. Now, Justice E.M. Heenan delivered his decision on the day of the application in June 2012, and remembering that there was no contradictor to Coffey's arguments, the judge found that all of the grounds could be seen to be reasonably arguable. He thought that it was reasonably arguable that the Section 37 process was a determinative step in the committee's decision-making process that could be subject to judicial review, that it was reasonably arguable that certain levels of procedural fairness should apply to this aspect of the process, and that perhaps it hadn't been afforded in this case. Perhaps there weren't sufficient reasons provided and an oral hearing should have been conducted. These were all he found to be reasonably arguable submissions. Now, following this decision, there was a slight sense that the door had been opened to challenge the processes and decision-making of the committee. It was sort of a sense that the judge had levelled some criticism of the way they go about things, but you have to bear in mind that this was all pending final determination of the court. So eventually the matter returned to the Supreme Court to deal with the substantive questions, and importantly this time the Minister for Environment and the Attorney General have intervened to counter the applicant's arguments. In summary, the grounds that Coffey raised was there a denial of procedural fairness because the committee did not hold a hearing before issuing the Section 37 notice, and that they didn't conduct a site investigation in the presence of all the parties prior to issuing the notice. Secondly, was the notice defective because it didn't inform the applicant of the case it was to meet? Was the notice defective because it failed to include the reasons behind which the committee issued it? Was the notice defective because it failed to deal with all the factual and legal matters relevant to the question of whether the applicant can be held responsible for remediation under the Act? Now, Justice Hall considered the matter and delivered his decision in 2013, so it was a different judge, got to recognise. Now, he essentially found that the grounds for review were without merit. In and of itself, he considered the Section 37 notice has no impact on the rights, duties or liabilities of those who receive it. This notice is merely an intermediate procedural step which may lead to a final decision but does not in and of itself affect the interest of the applicant. He emphasised that any action to challenge a decision of the committee in relation to responsibility for remediation ought to be made once a final decision has actually been handed down by the committee, and any appeal must come on a question of law, as Craig talked about earlier, under Sections 40 and 77 of the Act. And that's the only appropriate mechanism to conduct such reviews. He was critical, again, of the solicitors in this case for arguably wasting the courts and the community's time at launching these judicial review proceedings at this stage when the committee hadn't determined the matter fully. Now, it's well known that the committee has never conducted an oral hearing in its deliberation of decisions. It's a responsibility. And in industry, this is somewhat of a bugbear. But people also recognise that the committee is not really sufficiently resourced or empowered under the Act to do so. Now, Justice Hall noted that whilst Section 37(1)(e) and Section 37(1)(b) of the Act provide the ability or invite the person who receives the notice to provide written submissions to the committee, he looked at those terms and decided that they don't expressly or by necessary implication prevent the committee from conducting an oral hearing. However, when you look at other terms of the Act and the proper characterisation of the notice, he held that it couldn't be said that there was a particular level of procedural fairness that required the party to be afforded an oral hearing simply when they received the notice, or that they should conduct a site inspection. So the significance of the judgment, whereas Coffey number 1 appeared to open the door slightly to challenge decisions of the committee, Coffey number 2, we think, slams the door shut again. Again, it confirms the Chief Justice's decision in BP that appeal rights are limited and that the appeal must be determined by reference to an actual decision as to responsibility rather than what Justice Hall described as the mere possibility of such a decision. Again, the committee's approach to lawful authority was validated, and towards the end of the decision, Justice Hall, although he wasn't required to deal with it because he thought that the order nisi should be discharged, he gave some consideration to and dismissed the arguments of Coffey that in relation to defences to Environmental Protection Act contraventions. He felt that the onus of proving defence falls on the defendant believer, and it's reasonable for the Contaminated Sites Committee to reach a preliminary view that a contravention had occurred, and that could inform their preliminary decision, so to speak, when they issue the Section 37 notice. He also dismissed the suggestion that defences under the Criminal Code could be used in relation to these decisions, finding that there's an inconsistency between the EP Act and the Code, and to that effect, the EP Act prevails in the event of inconsistency. And finally, Justice Hall made some interesting observations throughout the decision and the judgment in relation to the operation of the committee and the Act. When he dismissed the argument that an oral hearing was required, he noted that the statutory context in which the Contaminated Sites Committee operates is inconsistent with any requirement to conduct an oral hearing, bearing in mind he did say that there's no express preclusion from conducting one, but practically speaking, the committee doesn't have any power to compel witnesses for cross-examination or to administer oaths. there's a chance that although there's a legal member on the committee, that for each decision they may be constituted without a legal member. And he also took a swipe at the sort of ongoing insistence from the legal profession that cross-examination is the be-all and end-all and will necessarily help to resolve conflicts. He suggested there's probably a professional bias from lawyers towards adversarial proceedings, whereas in cases like these, which are sort of involving highly complex and technical issues, written submissions and deciding them on the papers might actually be preferable to an oral hearing. There's also some interesting comments on the interplay between responsibility as it's determined under the Act and other legal obligations outside of the contaminated sites jurisdiction, which we'll touch upon just a bit later.
Thanks, Tom. So that's the end of the review of the cases. But what it suggests to us is that you wouldn't want to be a lawyer in situations like this, because the prospect of proceedings in the Supreme Court are fairly high risk. And as a consequence of these recent decisions, it's something that you would have to chasten a client to undertake. So it's important to understand that the Contaminated Sites Act is what it is. It's in the process of being reviewed, but it's unlikely that the mechanisms contained in the Act are going to be changed. So what we want to do, by way of summary, is talk about some of the lessons we've learned and apply some practical advice in relation to those cases, and give you a couple of points to take away. The first lesson is the importance of identifying risk, and as we reiterated again and again at the beginning, it's understanding the definition, and in particular the key elements of the definition. Not only identifying the presence of a contaminant above background levels, and there's clearly new guidance in that regard in relation to the release of the new method, and there's clearly a wealth of experience from a consultant's perspective to achieve that end. But it's also in going the next step, undertaking the risk assessment and determining where the risk lies in terms of environmental values and human health. And it's that aspect that we'd encourage everybody who's listening to be critical about reports you receive. Examine how they've arrived at their assessment of risk, and look in detail at the assumptions related to risk. The reasons why, because clearly the definition of contaminated has an impact on reporting, the obligation to report, and also has an implication for how the department classifies itself. The more certainty you have, the better. The less certainty you have, well, I'm afraid you're very likely to receive a classification that's not going to provide you the certainty that you need. It also impresses upon us the need for due diligence and the need to get that done early, either in a transaction stage or early in a planning stage. Because it's only through due diligence and that understanding of where your risk is that you will identify opportunities for mitigation. And that's a very important thing to take away. The second lesson is in relation to the importance of evidence. Now, I have to apologise to all those Bulldogs supporters.
Sorry, obviously from Craig's accent, he's not necessarily okay with Australian football mascots. I did remind him earlier that it was the Bombers, but anyway, I couldn't resist putting my tongue firmly in my cheek. I know who James Head is, for the avoidance of doubt. Evidence is key in all respects as a consequence of the decisions of the Supreme Court and also recent decisions of the Contaminated Sites Committee. And what those cases highlight is the really difficult task the Contaminated Sites Committee has, not only in identifying who has responsibility, but also procuring evidence. And as a consequence, what you'll find is that the Contaminated Sites Committee, in making a decision, in being required to make a decision, have to rely on the evidence that's provided to them and draw conclusions based on their judgment, as opposed to, in very many circumstances, a lack of science. We, representing landowners and operators that potentially pollute, can make that task inherently easier for them. And this is how we can do it. Firstly, in relation to effective
management of the process and also an audit of the process. And how you do that is setting out who does what, who is responsible for what in your leases, your subleases, your management agreements, setting out clear management plans as to how you go about managing a particular operation, managing the maintenance of a particular facility, and the like. The next aspect is in relation to incident management. Incidents it's often the case that they are swept under the carpet, but clearly as a consequence of recent experience, doing so is inherently misguided. Defined incident management procedures, the procurement of evidence and the retention of that evidence will stand you in good stead in circumstances that a site is subsequently required to be referred for assessment and subsequently classified, particularly to enable the Contaminated Sites Committee to make a determination. And then lastly, in relation to due diligence at an early stage. And the reason I've reiterated that here is that in a transactional situation, the opportunity arises very early on to undertake due diligence. If you don't obtain all the information you could possibly acquire and ask the right kinds of questions early on, you will never have another opportunity to access that information. It's a valuable opportunity in a transactional stage to procure that evidence and bank it in order that you're able to recreate history, so to speak, in circumstances that an incident has arise. The second lesson the third lesson, beg your pardon, arises as a consequence of comments made by Justice Hall in the Coffey LPM decision. Tom, if you wouldn't mind reiterating what that comment was.
Yeah. Justice Hall made a very interesting statement at paragraph 28 of his decision in Coffey number 2, to the effect that the decision as to responsibility for remediation, I quote, does not operate to determine responsibility for remediation other than for purposes of the Act. Nothing in the Act affects any right a person has at law to obtain damages, by reference to section 9(4) of the Act, and that neither the Act nor the decision of the committee affects any liability which might arise in contract or tort in respect of contamination of the land.
Now, what that means is that clearly it's well known that you cannot contract out of a determination of responsibility under the Contaminated Sites Act. That's apparent to everybody. However, what you can do is provide some contractual certainty in relation to who is responsible for what subsequent to that assessment. What that will do is also assist us for the Contaminated Sites Committee in attributing or avoiding assumptions being made in relation to who is responsible for what. And there are a couple of ways you can do that. And one, the most pivotal way, is in clarity of drafting. And in the circumstances of, say, a lease or some form of lease arrangement, it's in identifying what those contaminants are. It's in indicating who has responsibility for the operation of facilities, who has responsibility for cleaning up a particular incident, and also the level to which they clean it up. And in addition to that, warranties are inherently important, and also effective indemnity provisions. As Justice Hall made the comment, there is an opportunity for contractual provisions to apply, irrespective of a Contaminated Sites Committee decision. Now, lastly, it wouldn't be right if I, as a lawyer, didn't talk about risk avoidance or risk mitigation. The only mechanism there are, from a statute perspective, to avoid that risk are twofold. Well, firstly, in relation to the change of use provisions in the hierarchy of responsibility, which I would suggest are a change of use by stealth. Beware of them, because they are far-reaching. They may potentially implicate entities that don't appreciate that responsibility can be attributed to them. For instance, tenants who change use of a site such that remediation is required. So it's a very useful thing to have in the back of your mind in a transactional sense, and in also a planning or a development sense. The second aspect is the formal mechanism for transferring responsibility. And the only way that can occur is pursuant to under the Act is pursuant to Section 30. Now, as I understand it, no such formal transfers have been made. It has often been tried, but never quite achieved. And the reason for that is the requirement from the department for the entity accepting responsibility to open the books. It's an inherently difficult thing to ask of a prospective purchaser, and an inherently difficult thing to do from a corporate governance perspective. Equally, the department will also require that the mechanism or methodology for remediation be identified and costed to ensure that there is an ability to remediate it in accordance with the transfer. But what that means is a significant cost for the parties trying to engineer that exercise or that transfer to cost it up. And as we all know, environmental consultants aren't cheap. Maybe a little cheaper than lawyers, but they aren't cheap. Now, that's the last slide that I have. We have some time for questions, and what I might do is have a look at some of the questions that have been posed at a chat. And I noticed that there's one detractor from my proposed hierarchy of responsibility, and I think you're absolutely right. You know, I did preface my comments in that regard. And that's, if you remember the hierarchy, below the owner and occupier that changed the use, there was an owner pre-commencement who took with knowledge of contamination, and I suggested that it might be some form of punishment. Section 25 or Section 27(1)(c) does appear to make the responsibility subject to 25, but if you read Section 25, it also has this very same provision in it, subject to 27. So I'm very happy to have that discussion. It's a circular kind of argument. Very happy to have that discussion. Now, Tom, do you have a question?
Yeah, we've got a question here from Ken. Ken's asked, are there any controls in place by the department to ensure that entities are complying with their obligations under the Contaminated Sites Act?
Right. It's a very simple one to answer. Of course, there are. The Contaminated Sites Act has quite far-reaching powers from an enforcement perspective. To my knowledge, I don't think the department have ever used them. So they are there, but very rarely being used. Now, see that time is almost up, and what I might do is make a couple of closing remarks and invite you to contact us informally on the phone or for a cup of coffee if you'd like to discuss any aspect of this advice. Tom and I are fairly friendly, despite the fact that Tom sports a beard and wears a brown cardigan. We're always happy to have a chat.
Thank you, Craig and Tom. That brings us to the end of the webinar, and we hope you enjoyed it. We hope that you'll be able to join us for our next webinar on insolvency, which will be presented by partner Alison Robertson and solicitor Leo Milan. We will be sending out a recording of this for anyone that didn't get to attend, and we hope you enjoy the rest of your day. Thanks.